Good morning. My name is Paul Chandler, and now we're going to shift gears a little bit from the privacy discussion that we just heard. Today, Bob, Chris, and I are going to talk about why modern software development happens in a dynamic, changing environment, and the risks that this creates for development projects, and the legal doctrines and contract provisions that you can use to address these risks. Now, our time is limited, and we are very cognizant of the fact that lunch follows our talk. So this talk will be at a fairly high level, but if you have questions, Bob and I will be available afterwards. Our talk will consist of three parts. First, we're going to talk about why modern software is different than software of the past, the risk that this creates for, why it's developed in a dynamic environment, and the key issues and risks that this creates for software development projects. Next, we'll use a hypothetical to illustrate how these risks and challenges can arise in a typical software development project, as well as the legal arguments that each party may assert in a related dispute, and contracting tips that you can use to avoid the problems in the first place. Finally, we'll follow up with a few additional suggestions for mitigating risks in software development contracts. As you listen to our talk, we want you to keep in mind three takeaways that I'm going to give you now. First, we're talking about dynamic environments today because we often do not see this important area addressed in software development contracts. Second, even though the technical details of a software project may be beyond the purview of the deal lawyer, when you understand the risks and you get involved early, you can add significant value in helping your clients make informed decisions and avoid unanticipated legal problems and costs. And finally, if you don't address risk, the risk of these changes in your contract, you may still have arguments that result in a favorable outcome in the event of a dispute, but the outcomes will be far more uncertain than if you had addressed these issues in your contract.
And you'll have to deal with litigators.
Which is why Bob is here.
Right.
So first, why is today's software different than software of the past? It almost needs no explanation, but I'm going to give it to you anyway. Today's software is more complex than ever before. Consider examples that are all around us: enterprise resource planning systems, Internet of Things applications, mobile apps, the ubiquitous e-commerce websites. These systems have one key common feature, which has been referenced earlier in presentations, and that is they're integrated to various degrees to external systems. Consider, for instance, banks, credit card processors, third-party websites, data providers. We no longer live in a world where most software runs in a standalone manner on single computers. And it's not just the functionality of the software that's becoming more and more complex. The technology that underlies that functionality is changing rapidly. Consider the rise in the very recent past of big data, machine learning, artificial intelligence, in-memory database applications, as well as SaaS and cloud service offerings. So the rapid pace of this technology change, coupled with competitive pressures that are on businesses all the time, are leading businesses to expect their software development projects to create more workable code faster and for smaller budgets. And in order to deal with these pressures, there's a great trend toward heavy reliance on third-party building blocks like open source software and leveraging SaaS applications like Amazon Web Services and some of the more specific product offerings. This helps avoid the developers reinventing the wheel, and it may also be a necessity because of technology standards that are important to adopt. So let's take a step back for a second. We talked about integration with external systems as enabling new and amazing functionality in software, and the use of third-party building blocks to jumpstart development and lower development costs. But there are also risks to this, using third-party building blocks and integrating with external systems. Some of these risks have been widely discussed. For example, with respect to open source software, Linda Rhodes talked about it earlier this morning. The software generally comes without any warranty or indemnity protections. There's license compliance issues. It could be viral or have copyleft effects. But there's a key area that we do not see often discussed, and that is the dynamic nature of these things. What do we mean by dynamic? It's dynamic. The building blocks and external systems are dynamic because they're constantly changing and evolving. So this slide shows how we've categorized the changes between building block changes and external changes. And building block changes can be changes to open source software or any other pre-existing software because of a new update, the discovery of a security vulnerability, or the need to replace the building block because it's no longer supported. It becomes an orphan product. Maybe the supplier or the licensor goes bankrupt. With respect to external systems, the same kind of thing can happen. Websites, external systems can be redesigned. The data formats may change. Different things can happen. In fact, the changes may sometimes be because of changes to the building blocks that underlie those systems. So let's look at some common things between building block changes and external changes, just to frame this before we go on. We're talking about change that's imposed from the outside onto a project. And these are changes that are outside of the control of the parties to the contract. And for that reason, the typical change control provisions that you have in your software development contracts are not a good fit, because we're not talking about change that either party to the contract is initiating. And since these changes are imposed from the outside, it follows that they can happen at any time with little or no warning. They may not be the types of changes that are foreseeable at the time the parties enter into the contract. And of great concern, they may have major impacts on the developed software. What do I mean by that? And it should be obvious, but I'll explain. If it's a change to a building block that's used in the software, that might require the developed software to be rewritten in order to continue functioning. If it's a change to an external system, that may mean that, excuse me, the developed software and the external system no longer properly communicate. And when these things happen, these changes happen during the project, they can create great difficulty for the parties. It's been analogized to trying to change a flat tire on a moving car, not something you want to do frequently. And yet, this is an area that we often do not see addressed in contracts. We do not see contracts allocating the responsibility for dealing with these types of changes and allocating the risks. Now, Bob Chris is going to talk about what can happen when that occurs.
One way. All right. So the overarching issue here is whether your disputes that may arise because things have changed are going to be resolved by default rules, the common law doctrines that have addressed change, or whether you're going to address them specifically in a contract provision. So our approach here is we're going to discuss at a very high level a number of legal doctrines that one could use if one was confronted with a change in the building blocks or a change in the external environment. And I'll give you a preview. You're going, I think, to have the impression that it's quite uncertain what the result will be. These standards are quite vague, and they require a judge, jury, or arbitrator to make determinations of fact, and therefore, since the standard's vague, the result is uncertain. It's particularly uncertain in this area because there are, as of yet, we have found no published opinions that apply these doctrines or any other doctrines to change in the context of software development. And that could be because of matters getting settled. I see some quizzical faces out there. I was surprised myself. Or because these matters are arbitrated, and it's a confidential arbitration and we don't get a published opinion. But we have not found a specific application, and so in some sense we're on a cutting edge trying to apply doctrines that have developed in other contexts to software. So after you go through this process, you may conclude that if you can, it's more prudent to address these change issues in a contract rather than relying upon the common law. Okay, so briefly, and again, the point of this is not to make you experts in litigating these kinds of cases, just to give you a sense of what the doctrines are and the challenges in proving them. We have impracticability, frustration of purpose, mutual mistake, unilateral mistake. That's your toolbox, essentially, in dealing with changes that occur either with the building blocks, like the open source software, or some change in an external site that you're interacting with. And to get a little bit more granular, if we look at impracticability, the basics are an unanticipated event made the continued performance under the contract impracticable or impossible. Second, the non-occurrence of the event was a basic assumption on which the contract was made. Third, the party seeking to be excused from its obligations was not at fault for the impracticability or impossibility. And fourth, the party seeking to be excused does not assume the risk of the event. So absolutely crystal clear, right, how that'll work out in every context. Actually, of course not. The challenges in just establishing an impracticability defense include such things as what makes the performance impracticable, how much money has to be at stake, how much greater must the cost of performing be than what was originally envisioned to trigger the applicability of impracticability. You look at the case law, there's some cases that say or imply that if your cost overrun was 100%, maybe that might be enough. There are others that suggest it would have to be much greater. So it's very much up in the air. What's a basic assumption of the contract? People can very easily disagree about that. And did the party assume the risk? You know, how do you establish that? So lots of uncertainties in applying the doctrine of impracticability. Frustration of purpose, basics again. Unanticipated event undermines or destroys excuse me, or frustrates a party's principal purpose in making the contract, such that completing the transaction no longer makes any sense from the perspective of the party whose purpose has been frustrated. The frustration must be so severe that it's not fairly to be regarded as within the risk that was assumed by the adversely affected party under the contract. And finally, the non-occurrence of the frustrating event was a basic assumption on which the contract was made. So again, challenges. What's the basic assumption of the contract? Did the party assume the risk? What's the principal purpose of entering into this contract? Difficult factual questions. Depositions. Review of email. How it turns out in particular cases can be hard to predict. Turning to mutual mistake. Now, these two doctrines apply when something in the two that I just mentioned, impracticability, frustration of purpose, apply when the world changes after you execute the contract. These two that I'm going to talk about now, mutual mistake, unilateral mistake, they apply when you discover after the contract was executed that you made a mistake at the time that you entered into the contract. And so for mutual mistake, you have to show that both parties shared the same erroneous belief as to a material fact, so that their acts in entering into the contract didn't, in fact, accomplish their mutual intent. The mistake has to be mutual, substantial, and material, and it must exist at the time the contract was entered into. challenges here, include what is a fact. For example, is a security defect a fact, or is it an opinion based upon a cost-benefit risk analysis? One could argue that it's more opinion than fact. Was the mistake of fact material to a transaction? What this means is you would have to prove that, but for this mistake, the transaction would have been entered into, or maybe the terms would have been different, or the price would have been different, and how would the price have been different? All of which is somewhat uncertain. Unilateral mistake is essentially a mutual mistake, but it's a mistake made by only one side of the transaction, but it requires that the other side be aware that the counterparty is making the mistake. And the unilateral mistake doctrine has similar challenges to mutual mistake. So now, let's see how these doctrines might be applied in a hypothetical project. So, we have constructed this hypothetical project for a situation where a company wants to deploy a new website to display aggregated pricing information that it gathers from third-party websites, let's say airlines, and then displays on its own website to customers. You might consider this a screen scraping scenario. So the software vendor is retained to develop a custom bolt-on software that's going to bolt onto a open source software called, calling it Aggregator version 1. And that software combined is going to do the scraping and present it on the customer website. Now, the software contract involved here specifies specifically that Aggregator version 1 will be used. It specifies the parameters of the websites that are going to be scraped. It has a 90-day warranty that this will work, and it will scrape these websites and display the information to customers. It's a 90-day warranty. And there's an additional warranty in the contract that says whatever services are provided will be done in a good and workmanlike fashion, consistent with industry standards. Doesn't specify the industry standards, it just says it'll be consistent with them. So, here we are, we've got, right. So we have the system and the contract is signed, and after the project is underway, the first change, there's a security vulnerability in Aggregator version 1. It's publicly announced. The project jumps on it and they develop Aggregator version 2 that doesn't have the security vulnerability in it. The problem is that if you use Aggregator 2, version 2, it's going to be much more expensive to do the bolt-on work and to do all the other work because of various compatibility issues. So what we're going to do now is we're just going to give you a sample of what the arguments of the supplier and the customer might be, and to make it a little more interactive when we're finished with the arguments, and they'll be brief, I'm going to ask for a show of hands to see how you'd come out. You know, do you go for the supplier or do you go for the customer? And we won't take it personally at all up here which way you go. I'm just curious to see if, if there's a disagreement or, whatever. So I'm going to represent the supplier, and I'm going to start out by making the argument with regard to this particular issue of who's responsible for addressing this security vulnerability that's been identified after we signed the contract. I'm going to argue that, look, this contract specified that version 1 would be used. It actually mentioned version 1. And other companies are still using version 1, even though version 2 has been introduced. They don't think it's absolutely critical to correct this vulnerability for their business. So we never promised that there would be no security vulnerabilities in the software. That's not possible. I mean, there are always security vulnerabilities in software. So as far as we're concerned, this contract has not been breached. We can perform with version 1, and if you want to, for your own purposes, if you think it's necessary to correct this vulnerability for your business, that's out of scope. We need a change order, and we need some additional fees. That's argument number 1. Number 2, an impracticability argument. This is going to cost a fortune, and it was a basic assumption of the contract, even written in the contract, that version 1 would be used. So this is something that the parties did not expect to happen, and they didn't expect it to happen in large part because this has been used for 5 years and there's been no problem. So very expensive, did not anticipate this. It was a basic assumption that there would not be a serious vulnerability that had to be fixed. So the doctrine of impracticability should apply, and we should not have to perform this unless you pay extra. And finally, just another way of looking at it, mutual mistake. If this isn't due to an event that occurred after, the discovery of the vulnerability, it's due to the fact that in that code, at that very time we signed the contract, unknown to either of us, there was this vulnerability. We understood, because it had been used for over 5 years, that this software did not have a serious security vulnerability that had to be fixed. So for those reasons, if you want to change, you got to pay.
So if I were representing the customer, I might argue something like this. Hold on a minute. Both the product and the service warranties, reasonably interpreted, required that you provide software that met the business requirements without opening up the customer to the risk of a data breach or ransomware attacks. Our experts will testify that the vulnerability in question here creates an unreasonable risk to the customer's business, regardless of what other customers and companies have done in the industry. As to your commercial impracticability defense, the increased cost is not sufficiently great as to be unreasonable, and the evidence does not support a finding that the contract reflected any basic assumption regarding future hacking activity. Our experts will testify that participants in the industry do not assume that hackers won't find a way of exploiting vulnerabilities just because they haven't done so in the past 5 years. As to your mutual mistake defense, the customer made no assumption regarding the existence of defects in the open source software, so there was no mutual mistake. Customer relied upon the supplier to determine whether there were errors in the software that required correction.
Okay, so as promised, a show of hands, how many for the supplier? Okay, good number. And how many for the customer? Also a good number. See, this is what I'm telling you. This is, an actual demonstration that on the same facts, very reasonable, well-educated people will differ as to the responsibility if you leave it to these very general legal standards. So, segue to Paul to give us some contracting tips that might provide greater certainty.
Well, there are just a few to consider. The first is that I think we could tell from this discussion, the contract should focus on the business results that are required to be achieved by the project. In this case, you could say a system and a website that gathers and presents data from specified third-party websites, as opposed to the technical means to accomplish those results. And customers need to be aware that when you specify specific version numbers or building blocks or other technical means in a contract, that could be interpreted as a limitation on the supplier's performance obligations. It's also important for the contract to clarify that when the customer approves a version number or a building block or some other technical means, it is not a waiver of the supplier's performance obligations. The customer still relies on the supplier's technical expertise to perform the contract. That being said, there are still some circumstances where specifying technical requirements would be appropriate. For instance, with respect to code quality standards, where those standards and those requirements may bear on the ability of the software design to accommodate future changes, scalability, or compatibility with other systems. I just need to keep it in mind. Also, the contract should allocate responsibility for, as Linda Rhodes said earlier, identification, monitoring, and remediating software security vulnerabilities, as well as allocating the costs between the parties of achieving those things. And it's also important to think about how the vulnerabilities will be identified. They don't just walk right up and introduce themselves, as well as what the menu of options are for remediation. The point here is this is an evolving area. Many outcomes are possible. It really depends on the parties involved, the type of project, and the industry. There's another issue that is easy to understate the importance of. That is, the experts will tell us that software vulnerabilities, security vulnerabilities, appear in all software. But the real question is, which of these vulnerabilities is serious enough to require the supplier to repair and remove the item so it doesn't appear in the final product? Unfortunately, there is no agreed-upon universal definition of serious software security vulnerability. Yet, there are lists of vulnerabilities and scoring severity mechanisms that are available to parties to use as an objective standard to help avoid future debate about what's required to be, or what qualifies for remediation. For instance, there is the Open Web Application Security Project that publishes a top 10 list of vulnerabilities, as well as security by design information that can be helpful. There's also the NIST National Vulnerability Database, which includes common vulnerability scoring system weightings for those items. There are also third-party websites that put out the building blocks, like the open source projects may release lists of vulnerability in the code, perhaps at the same time that they release patches or earlier. These may not be perfect solutions in all cases, and we can't endorse any particular one for your project. You need to think about what's best for you. But they're starting points, and they do provide the benefit of an objective standard that helps the parties avoid debate during the project about what needs to be done. And another aspect of that is you should consider requiring the supplier or a third party identified in the contract to perform penetration testing to identify vulnerabilities. Perhaps the contract could specify that any vulnerabilities so identified would need to be corrected in the final product as a condition to acceptance. But again, that may set an objective standard that's appropriate in some applications like connected vehicles, but maybe not in others where that doesn't justify the cost. You could also consider splitting the cost of the vulnerability remediation as perhaps a more fair way of allocating costs and giving the customer an incentive to be thoughtful about what it requests, sort of like a copay in a doctor-patient relationship. And finally, the contract should require the supplier to perform some due diligence on the third-party building blocks that it intends to use for the project. That, in this case, would have helped identify the security, stability, maturity, and quality of the third-party building block, as well as the stability and reputation of the licensor. One final point. We're talking about security vulnerabilities, but these lessons really apply to other types of building block changes that I mentioned earlier. You need to consider addressing responsibility.
Okay, now we're back addressing this issue of change. The work has proceeded for a period of time, and we have our second change. Second change is that after a good deal of design and coding work has been done, the developer finds that several of the websites that were to be scraped have been re-engineered. Their parameters have been changed, and the custom bolt-on that the developer has been working on doesn't work anymore. And it's going to be real expensive to change the software to address now these new re-engineered websites that changed after the software development contract was entered into. So we're back to argument. We don't have anything in the contract to address this directly, so I'm going to argue again on behalf of the supplier that, look at this contract. It had parameters specified for the websites to be scraped, and that was for a reason, because we were limiting our liability to just those types of websites. And our system works great. If the parameters of the website match what's in our contract, what we've developed works. And so there's no breach. And if you want us to change that software to deal with websites of different parameters, that's a change order and a requirement for additional fees. Second, I'm anticipating you're going to argue that you have an expert on industry standards who's going to testify that we should have been checking with the websites. Well, we have our own expert who's going to say that's nonsense, that you don't check with these websites, and that's not what's expected in the industry. So we did not fail to perform that particular warranty. And as to commercial impracticability, we have an argument there too, because the parties understood, and it was a basic assumption of the contract, that the website, the third-party website, wasn't going to change in the foreseeable future, and that's why both parties agreed to put in the parameters in the contract itself. So for all of those reasons, if you want a change made in response to this third party, this external website, there has to be an additional contract and additional fees.
The contract included a warranty of compliance or performance in accordance with industry standards. And if that term means anything, it means, and our customers' experts will testify, that supplier had an obligation to contact the owners of the relevant websites and determine whether changes were planned. That's what's standard in the industry. And customer assumed that supplier included the parameters in the contract for the websites to be scraped based on this due diligence. And therefore, the statement of the parameters wasn't a limitation on supplier's performance, but rather an assurance that the developed software would be compatible with those websites to be scraped at the time of delivery. That's number one. Number two, you breached the services warranty by not performing that diligence. Number three, as to commercial impracticability, everybody knows that websites change all the time. So the change was foreseeable. This was a fixed price contract, and the supplier was obligated to perform due diligence on the third-party systems. Therefore, it is reasonable to conclude that the supplier assumed the risk of changes in those third-party websites. In addition, the increased cost is not so great as to be unreasonable. Finally, if the customer can get the work done for a cost that's lower than the cost of the existing contract, the customer may be able to argue frustration of purpose. If the contract doesn't require the supplier to produce software that scrapes all these sites, then the principal purpose of the contract has been frustrated, as the software is essentially useless.
Okay, so ladies and gentlemen of the jury or arbitrators, however you want to view it, show of hands. For the supplier, okay, a reasonable number, and for the customer. I think on this one the customer did better than the supplier. Okay.
Thank you.
We weren't going to take this personally. Okay. So, contracting lessons from this hypothetical, Paul.
Okay. I'm going to try to run through these quickly since time is growing short. So as with issue number 1, here again we see how important it is to specify the required results to be achieved by the project. In this case, it would have been a flat-out scraping the data off these websites without getting into the technical parameters. And acceptance should have been tied to these parameters being these results being achieved. Of course, depending on the websites, the project, there's many different ways to specify the required results. Secondly, the contract should explicitly require the supplier to perform due diligence on the external systems that are to be integrated, in part to find whether or not there are planned changes and other insights that could help improve the developed software. Now, keep in mind, it may be more feasible to do that due diligence on an external website where the integration is consensual, such as in a customer-supplier relationship. May be less feasible where you're scraping data off a website that doesn't want to be scraped. Bob.
Okay, and so final change, software is delivered, it's working great, but then 2 of the websites that are to be scraped, they change their design. And the system no longer works with regard to those 2 websites. And it's 120 days after go live. Recall that the warranty was for 90 days. And the customer consults an expert who informs the company that if there were ways to develop the software, to design it and code it, so that if this type of change occurred in the future, it would be much less expensive and difficult to react to it and make the changes necessary to scrape those websites. But that wasn't done at the time that the software was delivered. So, as the supplier, I'm going to argue 90 days means 90 days. That doesn't mean 120 days. Our contractual obligations have terminated. We can't be responsible for change forever. That's why we have a 90-day period. At some point, the customer has to take responsibility for the change in the world, and that point happened 30 days ago when the warranty expired. And also, our expert is going to testify that no, you don't have this obligation to be doing this due diligence, absent something in the contract requiring specifically that. Industry standards, general industry standards, don't require the kind of due diligence that the customer is going to be arguing for.
And I'm going to argue this is precisely what the services warranty requiring performance in accordance with industry standards was intended to catch. That warranty was not expressly limited to 90 days. And our expert will testify that had the supplier simply followed industry standards, the software would have been coded differently, would have been much less expensive and easy to recode, to modify, to accommodate these changes. And we don't agree regarding the due diligence item as we discussed earlier.
Our expert's smarter than your expert. Okay, so finally, show of hands. Supplier? Okay, and customer? Okay, this time the supplier, I think, did better, which one would think, given that we're now 120 days down the road. So, lessons.
So we just have a few lessons learned here to keep in mind, and I have to say, I think these are interesting points. There are a lot of interesting points in this talk, but these particularly interesting to me. I said twice earlier in these lessons that the customer should focus on the business results to be achieved by the project. This is an example where business results alone are not enough. In order to avoid a debate about whether or not the code was developed correctly and whether or not it's covered by industry standards, the customer should include code quality requirements in the contract. And these could be highly technical, so it's likely or possible at least that a third-party specialist may be needed to develop these contract requirements. In addition to the outward-looking due diligence we talked about earlier, this discussion highlights the need for the customer to be performing due diligence on the supplier that it's going to hire. And not just the types of due diligence areas that you might think of, but getting into the details of the code and the developers. What is their skill level? What is their experience? How do they write code? Do they write it the way that you think it's going to need to be written? This could be a key distinguishing factor in choosing between suppliers that are bidding on the same project. And finally, in this example, the warranty period was 90 days, but if it was 121 days, we wouldn't be having this discussion. So you should consider longer warranty periods. And how long should the warranty period be? Well, there's really no perfect answer, but one thing that customers could look at is what kind of system the software being developed would need to integrate with. So for instance, if we're talking about a retail system that might have annual holiday cycles and surges that stresses the system and maybe imposes changes on it at the same time, the customer might want to have a warranty period that's long enough to catch those business cycle changes. Okay, I think we're just about out of time. Let me just throw up the final slide. The quick point here is that the techniques we've talked about are aimed at trying to avoid the problems in the first place. Obviously, disputes can arise, and so you should always remember the more traditional contract protections of allowing the customer to have broad liberal termination rights, but what goes along with that is a license to use IP if you need it, the right to get source code, potentially hiring rights or at least knowledge transfer rights, and avoid giving exclusivity or doing other things that could frustrate your ability to take the project in-house. Thank you very much.
Thank you.